5 seconds to go. Start. A person is an accused of that offense or a mere witness. The said submission deserves to be discarded outrightly in view of the specific observations made by the three-judge bench in Vijay Madan Lal to the effect that the provisions of Chapter 12 of the Code, under which Section 160 falls, do not apply in all respects to deal with information derived relating to the commission of money laundering offence, much less investigation thereof. The precise observations made by the court in Vijay Madan Lal while considering the issue whether an ECIR could be equated with an FIR under the 1973 Code or not are reproduced as under. Considering the scheme of the 2002 Act, though the offence of money laundering is otherwise regarded as cognizable offence, cognizance whereof can be taken only by the authorities referred to in Section 48 of this Act and not by a jurisdictional police and punishable under Section 4 of the 2002 Act. Special complaint procedure is prescribed by law. This procedure overrides the procedure prescribed under 1973 Code to deal with other offences other than money laundering offences in the matter of registration of offence and inquiry investigation thereof. This special procedure must prevail in terms of Section 71 of the 2002 Act and also keeping in mind Section 65 of the same Act. In other words, the offence of money laundering cannot be registered by the jurisdictional police who is governed by the regime under Chapter 12 of the 1973 Code. The provisions of Chapter 12 of the 1973 Code do not apply in all respects to deal with information derived relating to commission of money laundering offence, much less investigation thereof. The dispensation regarding prevention of money laundering, attachment of proceeds of crime, and inquiry investigation of offence of money laundering up to filing of the complaint in respect of offence under Section 3 of the 2002 Act is fully governed by the provisions of the 2002 Act itself. To wit, regarding survey, searches, seizures, issuing summons, recording of statements of concerned persons, and calling upon production of documents, inquiry, investigation, arrest of persons involved in the offence of money laundering, including bail and attachment, confiscation, and vesting of property being proceeds of crime. Indeed, after arrest, the manner of dealing with such offender involved in offence of money laundering would then be governed by the provisions of the 1973 Code, as there are no inconsistent provisions in the 2002 Act in regard to production of the arrested person before the jurisdictional magistrate within 24 hours and also filing of the complaint before the special court within the statutory period prescribed in the 1973 Code for filing of police report if not released on bail before expiry thereof. In view of the above, it is abundantly clear that the dispensation regarding prevention of money laundering, attachment of proceeds of crime, and inquiry investigation of offence of money laundering, including issuing summons, recording of statements, calling upon persons for production of documents, etc., up to filing of the complaint in respect of offence under Section 3 of PMLA is fully governed by the provisions of the said Act itself. Stop.